Following on from the Supreme Court ruling in the case of the Royal Mencap Society versus Tomlinson-Blake, the government has amended its guidelines with regard to payment for employees who are required to sleep over, says Chris Wilkinson from Expert HR Solutions. The Supreme Court ruled that there is no entitlement to the national minimum wage for the time spent asleep during an employee's shift. The court held that the national minimum wage law contained provisions in relation to sleep in shifts that meant the claim had to fail. However, they also made it clear that this only applied to shifts where it is expected the worker will spend time asleep. Helpfully, the government has provided case studies where they believe the ruling would and would not apply, and we reproduce these here. In case study 1, the worker is allowed to sleep and only woken occasionally for tasks. In this case, the government advice is even if they are required to keep a, quote, listening ear, unquote, out, and therefore be awake but not performing tasks, or they can choose when they go to sleep, in either case they are not awake for work purposes and therefore the national minimum wage does not apply. In case study 2, the worker is again provided with sleeping facilities but woken occasionally to take calls. In this case, they are not entitled to the national minimum wage whilst asleep, but they are entitled to the national minimum wage whilst taking the work calls. In case study 3, the worker is allowed to nap during their night shift, but no sleeping facilities are provided, so they can only nap whilst in the chair. In this case, they would be entitled to the national minimum wage for their entire shift because no suitable sleeping facilities are provided. In case study 4, a worker is awoken to provide backup to another worker, but not required. In this case, the advice is that as they are awake for work purposes for that 1 hour, they are entitled to the national minimum wage for that period because they are awake for work purposes. In case study 5, the worker is woken frequently during the night for work purposes, contrary to original expectations. In this case, the worker is entitled to the national minimum wage for the entire period that they are awake for work purposes. This is a new case precedent, and we would advise you to give us a call if you have workers who are woken for work purposes during a night shift, as the advice may well change.